Let's bring in criminal defense attorney Brian Claypool and Mercedes Colwin, both now to break down this trial. I'd love to start with you, Brian. What do you think of the jury's verdict? Do you think they got it right?
Hey, Will, yeah, I think they got it right, and here's why. In most murder cases, you have what's called a manner of death. We knew the cause of death was blunt force trauma to O'Keefe's head, but there was no manner of death. What do I mean by that? Usually a gunshot or a knife wound. You didn't have that here. And the biggest hurdle for prosecutors was, how can you explain to a jury that there are no physical injuries to any portion of O'Keefe's body below his head? In other words, if the SUV that Reed was driving is going to hit O'Keefe and knock him on the ground to hit his head, Will, then he's going to have some injuries on his torso and his legs. He didn't have any of that. And I think another powerful piece of evidence was the snowplow driver. Remember that guy? He doesn't have an axe to grind in this case. He's not for the plaintiff or defendant. He came in and said, look, I was plowing that road at 2:40 a.m. I saw clearly in the yard where the body was supposed to be, and I didn't see a body. So that was another powerful piece of evidence. And then look, I think Martha touched on it. You had this video of Reed in her docuseries. Why is that important? Because the jury actually knew her possibly before the trial started, and if they didn't, they saw her testifying through video, and I think that really helped her. That was one of the game changers in this case. They could relate to her better, and that led to the acquittal.
Okay, Brian is pointing out holes in the prosecution's argument that amounts to what should be our legal standard, reasonable doubt, Mercedes. Do you believe that is exactly the analysis the jury was capable of finding, reasonable doubt, when it came to Karen Reed?
There's no doubt, Will, because when you look at number one, the medical examiner could not actually testify about the manner of death. That's the Commonwealth's key witness. That was the medical examiner. No axe to grind. Yet, exactly had Brian pointed out, the manner in which O'Keefe died was not, other than the blunt force trauma, but the manner in which he died was not able to be articulated. That's very much key. And the other very key issue that was brought out very effectively by the defense is the fact that law enforcement officer Proctor, this is the one who was the lead investigator, his memos were actually read to the jury. They were, we're going to get her. She's a whack job. All of the types of memos that you don't want to have written by law enforcement. You certainly don't want to have that done by a lead investigator. So the defense was very effective in saying, of course he was framed. Even the lead investigator had an axe to grind to target Karen Reed from the very beginning. He wasn't unbiased. He wanted to have her framed for this murder, for this death.
So Mercedes, you're now touching on the point that I wanted to get to. And that is, while appropriately our legal standard is reasonable doubt, it is a difficult concept, actually, for everyone to wrap their minds around. I'm a lawyer. I grew up around lawyers. You're both lawyers. We're trained to think analytically and try to plug in the holes and see if they have satisfied the standard of reasonable doubt. But the truth is, most people make their decisions based upon stories, and I've learned this by being overexposed to lawyers throughout my life. So I want to ask you both. We see how powerful the story of being framed is to the people outside the courtroom. What I'm curious from both of you is, how powerful and important is the alternate story? Not reasonable doubt, but an alternate story of Karen Reed being framed to those jurors. I'll go to you first, Mercedes.
Well, you certainly heard it from a bystander saying, I don't want to be that person. I don't want to be targeted by law enforcement. I don't want to be framed. It is absolutely a very effective way for a defense attorney to come forward and dismantle the prosecution's case by saying, it wasn't my client. It was someone else, and they're trying to frame her. And frankly, they had an expert. The dog bite expert was key. The dog bite expert that came for the defense said those injuries on his arm, that's most likely a dog bite, not from being struck by a tailgate.
And do you agree with that, Brian, that it's one thing to knock down someone else's argument, but actually in human psychology, what's incredibly powerful is to offer another argument that obviously people on the street latched onto, but do you think they did in the jury box as well? They latched onto this other positive story, positive in terms of they can tell themselves an alternate story of what happened to Karen Reed.
Will, absolutely. Why? There was already a docuseries on Netflix about this. So you're going into the second trial, And like you said, there's already a 4-episode story, a backstory that's gone on with Karen Read. So when this trial started, a lot of these jurors probably already knew what the backstory was. It's David versus Goliath. Everybody wants to be part of that. Everybody wants to be on David's side, and that was Karen Read. She's up against law enforcement. They failed to really conduct any interviews of anybody inside the house. There was alleged tampering with evidence, evidence missing, evidence allegedly framed or staged on the yard. You had all of that going on. Then on top of that, Will, you had a woman who's just like a lot of the people outside of the front of the courthouse. She has no prior criminal history. She's a working professional, and she comes across like a good old neighbor of everybody out there. And that's the backstory that really led to, I think, this acquittal. One last point. I think Mercedes is right, Will. That dog bite issue was crucial because it came, and then the guy in the house got rid of the dog. Juries like those stories too.
Right. And the point isn't to help us necessarily arrive at what's right or wrong or just or unjust, but to understand the way that we as humans make decisions in courtrooms and throughout our lives. We'll see, by the way, if a civil jury who only relies on a preponderance of the evidence feels the same way, but that's for a later date. Mercedes, Brian, great conversation. Thank you so much.
Thanks for having us.
Thanks.